we've got Mary Amelia Brown on Zoom.
Mary, no.
Yeah, sure.
You can. Kia ora speaking.
Kia ora, Mary Amelia. Welcome to the Parliament Bill Committee. You've got 5 minutes to talk to us.
Kia ora, Parliament Committee. Thank you first for having me here today and giving me this opportunity to address you all in this manner. I'm Mary Amelia of the family Brown, the creation of the Supreme Creator God, an essay and sui juris, have reached the age of majority and of sound mind and competent to testify. Do hereby declare the following, excuse me, the following truths to be the best of my knowledge and belief. 1. Declarant is the divine spirit incarnate as man. There is no proof to the contrary. 2. Declarant was born alive on the geographic location body known as Te Riu Amaui, Zealandia. There is no proof to the contrary. Declarant's given name is Mary Amelia and her family name is Brown. There is no proof to the contrary. 4. Declarant does not consent to being a New Zealand, Aotearoa citizen, nor any citizen of any corporate body, politic on earth, and as such is alien to the jurisdiction of Aotearoa, New Zealand. There is no proof to the contrary. 5. Declarant is always in peace and honour as an Te Reo Amaui Zealandia national, whereas declarant is not an enemy, belligerent, rebel or terrorist, subject to the Trading with the Enemy Act of November 2, 1914, the Emergency Banking Relief Act of March 9, 1933, the Terrorism Suppression Act of October 17, 2002, or any other public policy and or statute of Aotearoa, New Zealand, or its subsidiary states, possessions, or territory. There is no proof to the contrary. 6. Declarant does not consent to any express or implied contracts, trust indentures, trust instruments, bailment agreements, and or any agreements made either publicly or privately with any natural or artificial person, and hereby terminates all agreements on the grounds that they were previously signed by declarant under threat, duress, incompetence, or without full disclosure. Wherefore, declarant hereby declares all said contracts null and void, nunc pro tunc ab initio. There is no proof to the contrary. Declarant does not reside on any land lawfully ceded to Aotearoa, New Zealand, or any territory possession thereof. There is no proof to the contrary. 8. Declarant is not property of, surety for, or joined with, all caps, Mary Amelia Brown, lowercase, all capitals, Brown, Mary Amelia, lowercase, Brown, Mary Amelia, lowercase, Mary, all capitals, Brown, lowercase, Mary, or any derivation of that name either in spelling or capitis, and when in public goes only by the name Mary Amelia of the family Brown. There is no proof to the contrary. Excuse me. The declarant acknowledges and accepts the definitions relevant to registered organisations and goods under New Zealand law presented in the Companies Act 1993, the Incorporated Societies Act 1908, the Charitable Trust Act 1957, and the Personal Property Securities Act 1999. The declarant recognises that under the Sales of Goods Act 1908, goods include movable items such as animals and their unborn young. The Personal Property Securities Act 1999 also categorises animals and their offspring as tangible goods subject to ownership and security. The declarant affirms that there is no proof to the contrary concerning these definitions and classifications under New Zealand law. Excuse me.
Kia ora, Mary Amelia, your 5 minutes is completed. Thank you for
Kia ora.
making that submission.
Thank you.
Thank you.
Mr. Chair, do you have Catherine, or is there anyone else you'd like to serve to do?
Catherine Sixtus. Okay.
Oh, they're not the same.
No.
See, I think there's something a bit odd.
You think? All
What
right.
about this?
Catherine. We got Catherine?
Hello,
Catherine.
I'm Catherine.
Hi,
Yes,
Catherine. This is the Parliament Bill Select Committee. We have you
Okay.
for 5 minutes. Your time.
bless.
Members have read
Okay.
your submission. Thank you.
all right. Well, I've lost my voice a bit, but I'll try to get through. I just wanted to say that I don't believe that this is an omnibus bill in the definitions of an omnibus bill. I think that the omnibus bill was supposed to be to make small, minor alterations, but this seems to me to be a major constitutional shift, and I think that it should not be rushed through in an omnibus legislation. Geoffrey Palmer did write his letter, and he did say that there is not time to look over the entirety of this bill. The bill is extensive, and I think that we don't have enough time to evaluate the constitutional implications of what you've got there. So that's the first thing. Number two, in 2003, when Robin Cook went to Westminster and removed our right to petition to the Westminster Parliament and the right of appeal, we were promised that we would have a Supreme Court with a constitutional basis that we could file our cases at the Supreme Court. And one of the great privileges of our 1688 Bill of Rights is that we are permitted to call parliamentarians into the court when they are violating our 1688 Bill of Rights and not adhering to the liberties of the subjects and the limitations of the Crown. I don't have much time to speak, but I have put in a written submission. But I think that we always should have the right to go to the court. We've been blocked access. The Anglo-Saxon people of New Zealand have been blocked access for decades to the Waitangi Tribunal, and now we're being blocked access to the courts. We've been, Judge Cook created the strike law, and the citizens have been trying to go to the courts to defend their rights and struck out. Some of us have tried to enter the Waitangi Tribunal, and we've been denied access to the Waitangi Tribunal. And now the Parliament is trying to make a law to deny us the right to call ministers to the court. So that is another thing that I wanted to talk about. Secondly, we talk about the Treaty of Waitangi continuously, but in fact, in 1838, there was a professional bill of parliament for all those people that were of most of us, in fact, most of the South Island was held by German people, and the Upper North Island was held by French people, and both the French and the Germans ceded to England in 1838 based on, it was dependent on the New Zealand natives agreeing to that cessation. Now, that cessation was based on that we would be governed by Westminster law for all times to come, not some kind of tikanga law, not some kind of UN law, but Westminster law under our 1688 Bill of Rights. And it seems to me that there's an attempt to remove that from us. Also, I will just quickly add that in that 1838 provisional bill, we were promised our lands and hereditaments, and the hereditaments were established by John Ward over in Germany when we were promised our Protestant protections against all other religions, including the Catholic religion, the Torah religion, the Islamic religion, and our Protestant religion promises us freedom from cruel punishments, a freedom of speech, a freedom of forfeiture of person. So that's all I can get in, I suppose. Does anybody have any questions?
Might have time for one question about it. No, members don't have any questions. Thank you for your submission.
No, I'm sorry, but I think that that's
I'm sorry, but
I think there should be a question.
your time is completed.
So that you've listened to me, and I think that I ought to be permitted to have a question. Now, I said a lot of things.
No, no, it doesn't work like that.
Somebody
Your submission is
have a
completed
question.
now. Thank you.
Thank you, Catherine.
Okay, with another Zoom contribution from, I don't know how to say his name, John McDonald. Barry, I really
Barry?
want to say Barry, but it's
Barry?
probably
Wharry?
Wharry.
Could be.
Wharry. Let's ask him.
Kia ora, audio working?
Kia ora, John.
Yeah.
Yeah, welcome to the Parliament Bill Select Committee. Can you tell me how to pronounce your surname correctly? I don't have.
It's Wharry. It's an
Wharry.
obscure Irish name.
Thank you very much. Well, welcome to the committee. We've read your submission and you have 5 minutes with us.
So I'm addressing sections 14 to 28, where your bill is invoking the Bill of Rights 1688 and discussing parliamentary privilege. So I don't think that section of the Bill of Rights does not and apply to members of the Executive Council and their actions as ministers. The Bill of Rights 1688 was signed after 100 years before in England that had at least one civil war, at least one monarch had lost their head, and another monarch had abandoned the throne and was replaced by another monarch, and was effectively a coup. So the agreement 1688 Bill of Rights is an agreement to re-establish the monarchy and set up a constitutional document that New Zealand has inherited. So in the wake of the persecution of those times, they put protections in for freedom of speech and freedom of debate, and the importance of people in Parliament to question the authorities, which is good and something I support, because if decisions are made without criticism in a situation where criticism is suppressed or critics and dissidents persecuted, governments are going to make very bad decisions, and I think we saw that during the COVID times. What concerns me about this bill and what you might be trying to do is provide protections from accountability to ministers and members of the Executive Committee. I don't think the Bill of Rights 1688 entitles them to that. In fact, ministers are only mentioned in the 1688 Bill of Rights in the subjects of liberties to be allowed section. And I'll read an excerpt from that. May it be declared and enacted that all and singular the rights and liberties asserted and claimed in said declaration are true, ancient, and indubitable rights and liberties of the people of this kingdom, and so shall be esteemed, allowed, adjudged, deemed, and taken to be, and all and every the particulars aforesaid shall be firmly and strictly held and observed as they are expressed in the said declaration, and all officers and ministers whatsoever shall serve their majesties and successors according to the same in all times to come. So that's a commitment of both the Crown and all officers and ministers of the government to uphold the Bill of Rights 1688 for all time, and them acknowledging that these are ancient, true, and indubitable rights and liberties. So the Bill of Rights 1688 binds ministers to that level of accountability for those rights. Petitioning Parliament and freedom of speech are protected, but those clauses in the Bill of Rights 1688 don't specifically refer to ministers, so presumably open to all people, and ministers wielding the power of the state, and that can be used for arbitrary and abusive purposes, as we have seen in the last 4 years. They should not be protected from accountability and people questioning their motives, referring to clause 18 here. Questioning or establishing the credibility, motive, intention, or good faith of any person. I think we as people should be able to question that of ministers and officers of the Crown in courts, other tribunals, or in other settings. And the rest of it is in the document that I've sent to your committee.
Thank you. There's just 1 minute left. If there's any questions?
Take it if no one has it.
Thanks.
John, just a question about, I understand your point of view that ministers and members of the Executive Council shouldn't maintain parliamentary privilege, but how do you separate out the fact that they are, physically one and the same? They are MPs as well, and how would you ever draw that distinction in the House between ministers are only in the House by right of being MPs in the first instance?
Well, it depends if they're addressing the House as a minister on behalf of the minister, or they're addressing it as a representative of the people of their constituency. So if they're addressing the House as the Minister of Education, and they're talking about education policy and orders of the Executive Council affecting education, then in that situation, they're acting as a minister and an officer of the state, and they're in a role that's wielding the power of the state, so they should be accountable. If it's opposition MP representing their constituents and criticising the government, then they should get parliamentary privilege. But the minister is in their capacity. They could potentially have some system where they set aside their ministerial responsibilities for that debate and are addressing Parliament just as an MP, as a representative, and not as a minister. But if they're carrying the ministerial authority and those ministerial powers, or acting in that capacity on Parliament grounds, the debating chamber is not so much I'm concerned as, but it might give insight into their motivations and good faith as a minister, depending on what they say in their capacity as a minister when addressing Parliament.
Thank you. I'll have to think about that. Thank you.
Thank you for your submission. Much appreciated. Now, members, we have Will Dre for Zoom. Kia ora, Will. Thank you for your thoughtful submission.
to accept the Jonathan Ellis.
Brent, if you can hear me, can you please accept the promotion? Hello? Hi, Brent. Welcome to the Parliament Bill Select Committee. Members have read your submission and you have 5 minutes to speak to us.
Thank you very much. Good afternoon. First off, I'd just like to thank Kate, Diane and Jodie for helping me with this. I'm opposed to part 2 of the Parliamentary Privilege Section 9, bracket 6, the exemption of members, including the Speaker of the House, from obligation to attend the courts and tribunals. The Bill of Rights 1688 parliamentary privilege is not only afforded to the ministers, but a privilege of the people of New Zealand, United Kingdom, Australia, Ireland and Europe. Subsection 6, in brackets, that is the exemption of members from an obligation to attend a court or tribunal. That is repugnant to the subject liberties to be allowed. It is our indubitable right to participate in the courts freely and to summon any ministers when our ancient rights and liberties might be in danger of being subverted, to seek remedy. The Bill of Rights 1688 frequent parliaments. The subjects do claim and demand and insist upon all their undoubted rights and liberties. The subjects are particularly encouraged to pursue declarations from His Highness, the Prince of Orange, as the only means of obtaining full redress and a remedy therein. To my understanding, that means that the people of New Zealand always have the right to summon ministers to the court when vindicating and asserting their ancient rights and liberties. Now the second part, as a descendant of both native Pakeha and native and Maori ancestors, I am unique in that my ancestor Lewis Acker married a native princess on Stewart Island in the early 1800s. He bought land from a native chief pre-1840, which was ceded to the Crown in the Provisional Bill 1838 and later confiscated. There is no way for me to remedy this because I have been denied access to the Waitangi Tribunal to investigate my property rights as a Pakeha. I stand in solidarity with my elder sister, Catherine Sixtus, whose ancestors owned territories in Nelson and were survivors of the Wharry massacre in 1843. Because of this historical injustice, I am opposed to Part 6 of the Bill, Subpart 2, the Parliamentary Corporation Section 144, brackets 1A and B, that the body corporate may exercise all rights, powers and privileges over my individual person. Furthermore, I am opposed to Section 146, specific powers of Parliamentary Corporation subsection 2, to sell, transfer and assign lands that may include my ancient lands, which is a forfeiture of person without consent in the Bill of Rights 1688 Will and Mary. As the Honourable Winston Peters announced in Parliament, Middle New Zealand has had enough. This proposed bill is a travesty that is contrary to our constitutional right. Thank you.
Thank you very much for your submission. Are there any questions? Not from me. No, we don't have any questions for you, but we appreciate your submission. Thank you very much.
Thanks very much for hearing me.
We now have Wendy.
So that's for Dermot.
Wendy isn't online.